Good morning, good afternoon, students. I am here with Dr. Beauty Vambe, who is very kindly going to present with me this lecture on, which is a live class, but we're also recording it for all the students that cannot be here, on feedback for assignment 1, but also preparation for assignment 2. Which we thought was quite important. We'd like to give you as much detailed feedback on assignment 1 so that you get an idea of what our expectations were, not just the right answer, but what were our expectations. And Dr. Beauty Vambe will take you through that very, very well. And once she's done, then I will take over. Dr. Vambe, please go ahead.
Thank you, Ms. Rafia. Let me start now. So we're looking at the outline of the presentation. Here we're going to look at how to answer assignment 1, the sources that you should have looked at for the assignment, how to approach assignment 2, and we are going to look at what we refer to as plagiarism. Thank you. Next. So under assignment 1, we want you to briefly explain the differences. This is an example of a question. So it would come like, briefly explain the differences between a representation and a warranty, between an affirmative warranty and a promissory warranty, between a warranty of fact and a warranty of knowledge, and between a warranty of fact and a warranty of opinion. So here, we want you to give examples to illustrate the differences for all 4 comparisons. Yes, next slide. Sources. What is it that we consider as sources? Sources are where does the knowledge come from? Where do we get the knowledge? So here, what were the expectations? And then what were the sources that should have been consulted for one to be able to answer the question in the assignment? So here we've got the study guide, paragraph 8.2. That's Reineke et al. You'll find this at paragraph, is it page 362? And then we have the same thing, study guide, paragraph 8. We have pages, there we have 15.29 to 15.31, that is the chapter. And then we say, please do not copy and paste from these sources. These are where you get the answers from. You find everything that you need in the study guide. Next slide. And then we are going to look now at the assignment 1 feedback. So when we look at the sources, we always say that when you're looking at the sources or when you're looking for answers to your assignment, please start with the textbook. Look to see if a case or article would give you a deeper understanding. Remember, we will expect proper referencing in your writing. So we're looking at paragraph 2.38 to 2.46 of the textbook. That is where the source comes from. That is where your answer will come from. Yes. Next slide. So if it's an assignment, it's like you're writing academic writing. So we need an introduction, we need the discussion, and we need a conclusion. The introduction will briefly tell us what you're going to write, the key points. Then the discussion here will look at, for instance, if we're told to discuss the differences. So the introduction will tell us that the differences we are going to or like, for instance, you introduce by telling us that you're going to look at the differences between 1, 2, 3, 4. And then on the discussion, you introduce each and every difference on its own and tell us what it is that you find to be particular or peculiar, which is different from other forms of the differences that you're looking at. And then you conclude. When you conclude, you're wrapping up what you have given us. Tell us that I've looked at 1, 2, 3, 4 and found 1, 2, 3, 4. And then we want you to make sure not to copy and paste, and please do not refer to sources from the internet, blogs, or cases from other countries. Use what we have in the textbook. We know that it is sufficient and will enable you to come up with the answers that we look at. Yes, next slide. And then when you're answering your assignment, we want you to be brief. Set out the differences and no similarities between a representation and a warranty. So I want to see the differences. What is it that is different? And then between an affirmative warranty and a promissory warranty, between a warranty of fact and a warranty of knowledge, and between a warranty of fact and a warranty of opinion. So these are the differences that I want you to set out, or that we expect you to come out with in your answer. And then on the representation, we are looking at, or this is equal to what we call pre-contractual statement. And then when we talk of a warranty, this is the term of a contract. When we talk of affirmative warranty, we're looking at the concerns. This concerns the present or the past. It also looks at the promissory warranty and concerns the future. We're also looking at the warranty of fact, breached if fact incorrect, warranty of knowledge, breached if ensured new fact is incorrect. We are also looking at when we're looking at the warranty of fact, we're looking at if it says what breached if fact incorrect, warranty of opinion, breached if ensured did not hold that opinion as a fact. So we want to see these slight differences. Yes, next slide. And then steps to putting it in your words. Like we say, we do not want plagiarism. So when you find something in the textbook, how best can you put it in your own words, which doesn't show that you copied exact word for words? Of course, there are other words that you need to use as we give you, but we want to see your presentation. Are you able to write English in an academic manner? So the first point is that even though this exam book is open, you can only put it in your words using the 4 hours if you have studied the material before the exam. And then according to Prof. Sunil Gear, the prof has suggested the following steps. Step number 1, read. So when they say read, it means this is the part of you summarizing your work. So take out what is important to you. Step number 2, put what you have read in your own words. This is, so what do you understand from this? And then step number 3, compare what you have written against the original source. That is, did I change it into my own words? And then step number 4, add the citation. The citation here we mean, so tell me where you got the answer from. If it's from the textbook, tell me the paragraph and the page. If it's someone else's direct speech, you put the quotations. Yeah, that's what I can say. We can also get things from the study guide. You tell us, it's the study guide, this page, this paragraph. Yes, next. So an example here we're having. So this is a passage from a study guide. Put it, he said, put into your own words. So it says, point number 1, underlying the whole idea of insurance as we know it today is the notion of the spreading of risk. One of the characteristics of human existence is that people, their assets and their expectations are continuously under threat. The calamities to which man is exposed create a need for security and protection. This need may be satisfied in a number of ways. One of them is to distribute the risk of the occurrence of undesirable events among a number of persons. This is known as the spreading of risk. Insurance is preeminently an instrument for the spreading of risk among a number of people who are all exposed to the same or comparable dangers or risks. Yes, next. So this is another example.
the next part is on how to deal with the problem type questions, which is
Yes.
assignment 2 type questions. So here I think it's just, what would you need to keep? That is quite important, and you would need to, you can, there's specific wording that is important for insurance law, like spreading of risk is a very specific term. You wouldn't necessarily change that. You'd have to explain what that is. The idea is don't do a replace, the control, find, control, replace. Explain it. You can either explain it or you can say that it's about making sure that the person carrying the risk is not the only person who carries the risk. And that tells you that is about spreading of risk. So these are very specific terminologies that you will have to show us. You can understand what that terminology means. Yeah. So I think that was the idea here, is to take that passage and then highlight one or two things there that you can utilize. Or, instead of saying that insurance is an instrument for the spreading of risk, you can say it is a way that you can take away that burden on one singular person and make sure that there are more people that carry that risk. So that would, it would mean the same thing. So just to highlight how you can do it. And the idea is not to give you exact words, because that's also not useful, because you might just use those. But we want to show when you have specific insurance law concepts, we would like to see that you understand them. And I know that in the narrated PowerPoints and so forth, we do go over some of these things. In your book, there's a lot of these discussions. You are finally a student, and you once you engage with that, you will have a relatively clear idea in your own head what that is.
Okay, thank you, Ms.
Thank you,
Rafia.
Thank you.
Yes, you
Thank
can
you,
move
Dr.
on to the
Wang.
next slide. Yes, on
Sure.
the problem. Yes.
I will. Oh gosh, it seems to not listen to me unless I click. So you will see that your assignment 2 deals with the problem type question, and the reason we have in assignment 1 a more straightforward question, and then in assignment 2 we deal with problem type questions, is simply that they reflect the kind of questions you will have in the exam paper. So we are preparing you in the short term for the exam paper. And in the longer term, we are ensuring that you've engaged with not just the textbook, which you had to do for assignment 1 and the study guide, but in the problem type questions, you will have to engage with the cases. So we are making sure that you are actually going through all of the materials that you're meant to be reading, and preparing yourself to be a good lawyer out in the public one day. So just to talk to you, and I know the numbers in this problem are just crazy. You could never buy a house for 1,000 rand. But let's let's deal with it as a problem. And remember, these are fictional things. We the numbers themselves, and perhaps the reason I kept this number in is that sometimes we could, sometimes the numbers are important, and here they are, you'll see, and the amount itself isn't. So the difference is important, but not the amount itself. So here, of course, a person has bought a house, they have insured it for slightly higher than the actual value, keeping in mind that a fixed asset like a house increases in value. The only thing is that when damage occurs, here in this case, it's destroyed by fire, the actual value of the house was more than what they had already insured for, which was already a higher value. So now you have to have this poor insured person who has actually lost in value more than they have insured for. And what does that mean for them? Can they claim the higher value, the highest value here, which is 1,200? Should they claim what they had insured for, or the value of the house? And here there's a few things that come in. Firstly, of course, in insurance, like I think most parts of South African law, we do not compensate people for more than their loss. Yes, that's the first thing. So you will never be compensated for more than the actual loss. However, if you have agreed in a contract, which is usually set down, that you have agreed. Now you've given a market value of the house. That's what you're insuring it for. It is deemed that you have agreed that is the value of the house. So now that is the agreement that you have between yourself and the insurance company. So how do you advise then this client? So firstly, having read the question, you have to identify what is the legal problem. The legal problem is, of course, what can the insured claim for? And then you have to set out the relevant principles. And here, of course, we're talking about what can a person claim for? Are they overinsured, underinsured? What is underinsurance? Underinsurance is where you insure yourself for an amount that is less than the actual value. And in the first instance, they had thought at the onset that they had Beauty, can you allow the student in?
Yes, thank you.
Thank you. At the onset, when they signed on to the contract, they had actually overinsured because they had insured more than the actual value for which they bought the house. But over time, that became an underinsurance because the value increased. So what happens is that you can only claim what you insured for. So sadly, in this case, you would have to tell your client they cannot claim 1,200, but they can claim up to 1,100 or whatever whichever is smaller. So maybe it is not a full loss of the house, for example. Then it would be a proportion of it. So here, firstly, it will be some insured, or loss, but whichever is smaller. And this would apply even if there's an average clause. And an average clause is something that is usually used in marine insurance. It's very rarely used in other insurances, but sometimes it is. And that is where we average out the what you insured versus the actual value of the thing, and we average between those. In this case, of course, it wouldn't make a difference between the average between the initial value of the house and the final value of the house is 1,100, which is the sum insured. So here, that policy, even if it contained an average clause, would not make a difference. So here you would get marks, and you see there are 5 marks there. You would get a mark for talking about underinsurance as well as overinsurance and what that would mean in monetary terms. What would be recoverable, a reference to the average clause, and then finally you have to give actual advice to the client. You have to say what she can. That is always important. Just remember that bit. Students tend to lose that 1 mark of just saying to them, you can claim this much, which is fairly an easy one. Another sample question here, Namusa insures her restaurant against all risks, which is a very good idea to do, just in case you have difficult clients. And then we give you a list of different things, and there you'll see it's 2 marks. It should be 10, not 5 there, but there are 2 mark questions, and you have to say if they have will they have a claim. So the first mark that you get for any of these is to say yes or no. Okay, so that's the first mark, and then you have to give the reason for it. So it's all risk means everything but does not include normal wear and tear or intentional action by the insured. Okay. So while preparing a meal, she negligently causes a fire which damages. It's negligence, it's not intentional. So yes, there will be a claim. Yes, and there'll be a claim because it's accidental, and that is covered under all risk. So in the second instance, she intentionally causes a fire. Guess what? The answer is no, because she intentionally caused it. So therefore, she will not have a claim. One of the guests starts a fire. Here, the guest's intention is not important because they're not the insured. If whether they intentionally caused the fire or negligently, it will fall under all risk because that guest of the restaurant is not the insured. So there will be a claim. The restaurant is damaged because of bad quality cement. And here, this is very important. It goes back to Assignment 1, remember when we talked about warranty of fact and warranty of opinion? So if you say you have insured the building, to your knowledge, the building has been, built according to the right requirements set by the municipality or whatever it is. So here you are giving some form of warranty. The question is it a warranty of fact? Is it a warranty of opinion? Is it a warranty of knowledge? If it's a fact, you're saying it is built. You're not saying to my knowledge. Then there will not be a claim. If it's a warranty of opinion, if it's just your opinion, then perhaps it doesn't matter because you're not somebody who builds. You don't have any the knowledge of the building, materials and so forth and things like that. Even of knowledge, I mean, you might have gotten a certificate. To your knowledge, it is right, but they got it fraudulently. So yeah, there will be a case. In most instances, when you are guaranteeing as an insured and you're not somebody who's in the construction industry, you are not giving a warranty of fact. You're giving a warranty of either knowledge or opinion. So in this instance, there will be cover under all risk. Where lightning causes, and she was doing something unlawful. She was unlawfully distilling brandy. I mean, I would naturally think of other things that you can brew, but brandy seems like a very flammable thing, so we put that in. And here, this is quite important because I know logically it sounds like if you're doing something wrong, it seems like you should not have a claim. Yes? And that was the case until a very specific decision, and it doesn't come to my mind right now, but they decided even if you're doing something illegal, unless it is connected to the cause of the loss, you will have a claim. So here, lightning causes a fire, not the brandy, not the distilling, the unlawful distilling, and therefore she would actually have a claim. If the fire was caused by the distilling, then she would not have a cause. So there you have to, that nuance comes in. And just to go back to assignment 1, just to clarify, all of those things that we are asking you to remember, those warranties and is this a misrepresentation of a breach of warranty? Those are incredibly important. A lot of cases hinge on whether a statement qualifies as one thing or the other. When you and how easy it is for the insurance to say they will not recognize your claim. What happens is if you have a warranty, and in some of these instances there is, where she's made certain statements that are warranties that would probably be in the contract, immediately the company can repudiate the contract if they choose. That's it. They don't even have to prove many other things. They will just say breach of warranties, breach of contract. We will not pay your claim. Where there aren't warranties in place, misrepresentations comes to say the insurance companies where somebody's acting unlawfully, but they would have to prove delictual liability, and that is a little bit more difficult to do. So these things are very important because your client may or may not have an easy way out if you work for the insurance company, or your client might have a claim because it's the wording of it. So that nuance and that wording becomes quite important for you to understand. So please keep in mind, of course, you're getting a mark for every yes or no that you're saying, but you have to give us briefly, very briefly, a good reason in a question like this. Now, third question, Trevor ensures is on life and he appoints his secretary as the sole beneficiary. On his death, his son finds out and he's very, very upset because the rest of his estate is worth nothing. So what can Barry do? And having given this question in exams before, I understand students who feel very sorry for Barry, and there were quite a few that said, well, he should just say that they should disregard this because he's the son and the secretary doesn't matter. Maybe the secretary was a very important person in his life who helped him at some point in his business and helped set him up and all of those sort of things. We don't know. People have all sorts of reasons for doing this. But if you have a nominated heir for your insurance, you can nominate anyone. You could set up a trust for your pets. You can do anything, and your actual heirs, like your son or your wife or whoever, cannot dispute that unless they can try and show that if something was unlawful, that something nefarious was happening. So in this instance, you again have to tell to Barry, firstly, that Trevor has the right to insure his own life and nominate and appoint anyone as the sole beneficiary. And Liza, of course, has in your legal position. Then you have to explain it to Liza as well. What does that mean? If somebody is appointed as a nominated beneficiary, they have to, and this is the interesting thing. There's a little bit of a discussion in your textbook about, is the contract between Trevor and Liza, but what about the company? Is the contract between Trevor, Liza, and the company, or the company and Liza? There's a whole question around, is it a contract in favor of a third party? So do engage with that, because I would like to see some of that here. You would have to explain that up to the point of his death, she has no rights. But once Trevor dies and she's now the nominated beneficiary, she has to actually act when the insurance company says to her, this is, you're the sole beneficiary. She actually has to accept being the sole beneficiary to get the 10 million rand. So there is that sort of second step that for Liza that she needs to take. So here you have to give the legal position to both Barry and Liza, and 5 marks. You 2 marks your explanation to Barry, 2 marks, 3 marks to explain to Liza, what she can do. She can also decide not to, which I would never advise a client never to accept monetary benefits that are coming their way, because then you are not acting as a good lawyer. So just keeping that in mind, you have to not try and say to Liza, you should feel bad about Barry and things like that in your answer, because you have to be objective. So here, in this one, I've put it in here because here you have a case that you have to look at. And we would expect you to tell me that there is a case where something similar happened. You have to name it. I'm not going to tell you what it is. You're going to have to go look at it on your own. And here, the question here, what is the legal conundrum that they're dealing with? The legal conundrum is that if you are not the owner of an object, can you insure it if you have an interest through another person? So here, the husband, of course, insures it in his own name, but it's actually owned by Alice. And the court looked at it and said, well, when people are married to each other, even if they're married out of community or property, they have a responsibility to take care of each other. So part of that is that they can, and if they want to, they can take insurance out to protect each other's property. So this, and not only in the case of married couples, if you are a shareholder in a business, you can take out insurance because you have an insurable interest. And this question really deals with, does Jerome have an insurable interest? And there's a whole chapter on it. Read it. It explains what qualifies as an insurable interest and things like that. And you would, of course, you'll get marks for mentioning the case. You'll get marks for explaining what insurable interest is. And applying the decision in that case to these facts to tell Jerome, if he has a claim, that whether or not the insurer can say that he does not have an insurable. And guess what? There's a little bit of a hint in the question itself. The insurer contends Jerome has no insurable interest. You immediately know you need to go there. And I'm just going to talk to plagiarism because it's incredibly important to talk to plagiarism at every opportunity we get to talk to students, and that is, please don't do it. It is seen, and Dr. Bombay has already talked to it. Put things in your own words. Really, it shows a lack of confidence in your own writing. So please don't do that. We don't want to see dishonesty. It really will impact your career very badly. And sometimes it's very easy, but there's a continuum. Sometimes it's just, paraphrasing badly, or, taking things as is and just copying and pasting it. Just remember, reference always reference your answers. Make sure we know where they come from. Yeah, so I'm not gonna go into this much because Dr. Bombay already did. And remember, we are assessing you on your understanding of the legal principles. As I said, we want to see how much you understand. So when it's insurable interest, you have to explain to us what insurable interest is. Please don't just copy and paste it. Tell us in your own words. We are looking to that. We want to see that because that makes us feel very confident that you are going to be a person who's going to deal with insurance clients very well. So don't do a replace and find. That's always my thing. Remember, assignments are open book always. Exams are also open book. It's only 4 hours, but assignments, you have a lot of time to do this. Please take your time, look for these things. Don't prepare for these things last minute. I will also, I just want to say this. There have been issues with my modules. And please make sure that, as you know, you attempt these assignments well in time, you upload them in time. The system for assignment 1, I know there was some instability. I'm so glad that most of you were able to do it. Remember, you have to do at least one of the 2 assignments. And I would encourage you to do both just to see how well you understand the material. So please do so. Dr. Wambe, I see your hand is up. Go ahead.
Yes, thank you, Madam Miss Rafia. Thank you for the presentation. I mean, you really explained what students are supposed to do when they're approaching these problem type questions, and it was well explained. Just to have one question, Miss. Students usually ask that assignment 1, what chapters are we looking at? And assignment 2, what chapters are we looking at? Can you help us on that one? Thank you.
I would, I would love to be able to tell you. But and this is the thing. For assignment 1, I was learning unit 3 and 4 that you had to look at to get your answers. And it's fairly easy. I think once you have that, you understand the textbook talks to all those definitions. And we actually stated that in the assignment question. However, you've had that almost first attempt at answering insurance law questions. With the second one, we would like you to go through, find what the question is asking, find the right spaces. You are final year students. Please, engage with the study guide, the textbook, the prescribed cases and articles before answering. Final year students, you know how to find these things. So even though we helped you in the first assignment, the second assignment, I don't think we do. We don't give you a hint.
Oh, thank you, Ms. Rafia. Thank you so much. And maybe our student Paradzai Mutemi, do you have any questions you want to ask? Yeah, maybe we can stop sharing. I mean, we can stop recording, Ms. Rafia. Paradzai, do you have anything you want to ask?
Good afternoon. No, I joined in a little bit late, so I don't have any questions